Hello and welcome to the DMH Stallard Employment Law podcast. Relationships at work are nothing new, but they throw up a variety of issues, both legal and operational, that make them a challenge for most organisations. It's also fair to say that there's not one single correct way to seek to manage relationships at work or control the risks that arise from them, as the right approach will differ depending on the nature of the organisation and the sector in which it operates. But right now we've seen a lot of attention on the issue of sexual harassment, not least because we've got a new duty on employers to take reasonable steps to prevent it in the workplace coming in. And we will touch on that in today's discussion, but we also wanted to look at the issue of relationships at work more broadly. Things like whether there's such a thing as a good relationship at work. Would it be madness to actively encourage them? And importantly, how do you manage situations where a relationship has or is breaking down or broken down? I'm Adam Williams, and with me to discuss the future or the current state of play of relationships at work are Rustam Tata, partner and head of the employment group at DMH Stallard. And Rustam has a wealth of experience in advising businesses in complex employee relation issues, including the sorts of issues we'll be talking about today. And Abigail Mayno, also a partner in the employment group with many years of experience advising organisations both large and small and across a variety of sectors. And Abigail regularly assists employers with fine-tuning and honing their approach to managing complex and difficult issues arising between employees. So we're well set to have our discussion on relationships at work today. So Rustam, if I can start with you, employers will be alive to the prospect of relationships at work and the associated risks, and many, of course, will have created policies that look to address this. But to start, can we just focus in on why this is an important issue for employers to set the scene? What are the key risks?
Thanks, Adam. So I think there are probably two main areas of risk or perceived risk. The first is a reputational one, and that's very much come to the fore over the last few years, and of course now very recently with the reports in relation to the late Mohammed Al-Fayed's behaviour at Harrods. So anything where particularly there's a power imbalance between the two individuals in the relationship, where that can go wrong, or even where the relationship itself doesn't appear to be going wrong, but the perception of other colleagues. So you go from the reputational then into the sort of operational management piece for how colleagues will view other colleagues, where there'll be a concern about favoritism, whether it's around promotion or pay rises or anything else.
Yeah, no, that's fantastic to set the scene for us. Abigail, we'll dig into some of the more challenging or interesting facets of those areas in a moment. But with that context in mind, I'm going to stick my neck out and say it seems pretty clear that the case for having a policy on relationships at work will be strong for the vast majority of employers. Do you agree with that? And if so, what are the hallmarks, talking generally, of a good policy?
Yeah, thanks, Adam. I do think it's sensible for the vast majority of employers to think about a policy in the context of setting expectations principally, and for all the matters that Rustam touched on in terms of sort of commercial and operational risks. And also you mentioned at the start there is that new duty to prevent sexual harassment in the workplace, and that seems to me to be, or the relationships at work seems to me to be an area of fertile ground for litigation or people raising complaints. You can see a possibility of an uptick in claims from individuals who were in relationships in the workplace that might have ended or soured. And I think in that context and that overall duty, it's sensible to set some parameters and expectations as an employer as to whether you want to have some a complete ban or some parameters around disclosing and managing those workplace relationships, and it helps to have that level playing field amongst different levels of the organisation. In terms of what makes a good policy, it is, as I say, setting out those expectations, being clear on the employer's stance, perhaps what types of relationships are deemed acceptable or reasons why certain relationships are discouraged or not permitted, perhaps to touch on Rustam's point, where there's a power dynamic or there's a line management relationship there. And how and when an employer will need or expect those relationships to be declared, and what may happen if there are line management relationships there, such as will one party be moved to a different line manager, etc.
Yeah, that's a really good point about it's an opportunity, isn't it, potentially to foreshadow the approach, which, as long as on the face of it looks well thought through and broadly sensible, may empower the employer subsequently, in that they won't be surprising an employee and appearing to be making it up on the spot in terms of how you deal with it. And it isn't always necessarily going to be dismissal, I think, is what you're saying. And which of the two people in the relationship do you terminate employment for as well?
Yeah.
So
or move. Yeah.
Or indeed move. Exactly. Yeah. So there's lots in there that's almost a nice summary of some of the points we'll dig into in a bit's time. Rustam, do you have any other elements you would recommend or you perceive has maybe been an area of particular difficulty that maybe has been missed in some policies? You see it lacking? I mean, I would touch myself on the point about declaring. Is there a point about the duty to disclose, and do you need to be careful about how far and wide that duty applies? But I don't want to push you in that direction.
No. I think I think there's a whole initial conceptual piece to think about, and that's really, I suppose, how firmly the employer is going to go at it, and is there a blanket ban? Maybe we can talk about that a little bit later. Whether there is a duty to disclose, whether that duty to disclose is qualified or only arises in certain circumstances, and what about where the position or the relationship changes? So that becomes very difficult. I think the other area that is potentially very problematic and very sensitive is, of course, not all relationships at work will be negative. Most employers want to encourage good working relationships between colleagues. The issue is, of course, where either it potentially crosses an acceptable line for the employer, or, of course, for one or more of the employees, or the perception of colleagues that the boundaries, as it were, between individuals have been breached. But I think there's one other point just to pick up here, and maybe again we come back to it if we have time, which is who is being protected and from what. And I think whilst some of the sort of headline grabbing stories, immediately one is looking in terms of victims, or using the language perhaps of victims and what an employer needs to do to prevent that happening. I think in this area, it's probably fair to say that employers are also very often considering their own or its own interests, and those interests are not necessarily completely aligned with those of both of the employees, perhaps in a relationship. So it is, I think, quite a difficult area, and sometimes quite a difficult circle to square.
Yeah, and clearly that last point you made there is one of those contexts in which the risk of employee relations issues and dispute is probably ratcheted up a few notches, where the employee is perceiving that the action being taken under the policy, which may be negative for them, is driven more by business or organisational needs and wants than actually one that's genuinely seeking to protect one or another individual.
But that doesn't, to be clear, that doesn't necessarily make it wrong. It's just that the language of protection. Sometimes then the concern can be that what is being protected is more the employer's interest, and in a sense, it is the employer's interest, because it's the employer's interest to ensure that there's a consistent application of the policy. But as with any policy that you seek to apply consistently, of course, there will always be, as it were, hard or difficult cases that arise.
Yes, Rustam, and on that point, Abigail, I've seen situations where the relationship at work was not so much the problem itself that triggered the dispute, but rather the perception that the employer was treating certain groups within the organisation differently to others under its policy. The couple, for want of a better expression, in question at the time felt that they were being treated more negatively than maybe another example that they'd seen, and then maybe they'd learned about informally rather than formally. And sometimes the perception is not accurate. But how important is consistency of approach? And I mean that in terms of both maybe responding to a failure to disclose a relationship, which is often where employers in their policy say we do expect you to disclose, and then perhaps the response to handling the relationship or trying to control it once it becomes known.
Yeah, no, and you're absolutely right. I think the danger, and this is the danger with any policy and the application of any policy for employers, is that it's not applied consistently or sufficiently consistently, and that creates tension and complaints within the workforce. I mean, the sort of classic example is where, we may come on to talk about this a little bit more as we go on. There is someone very senior within an organisation who is deemed sort of, for want of a better word, untouchable, and therefore the policy isn't, applied in the same way to them as it might be to a more junior couple within an organisation, and how that perception, both from a legal perspective, if there's any sort of discrimination claim risk there, but also from an employee relations perspective, how that's received. But having said that, I suppose I can envisage situations where individuals may not feel comfortable disclosing a relationship, and perhaps an employer needs to, as Rustam said, there are always considerations when applying a policy that will need to be thought through. For example, if there's a same-sex relationship that the individuals perhaps haven't disclosed their sexuality, don't want to, feel that they want to keep that private, and so don't follow the policy. How is an employer going to approach that in the same way, or is there going to be a degree of discretion applied there? So as with any policy, you can have things sort of written down. I think inevitably there will be degrees of discretion, appropriate discretion, taking into account specific situations. But I think the starting point, to answer your question, is starting point is to act with consistency, unless there's good reason to apply any form of discretion.
Yeah, really helpful. One of the points you touched on there, I think, draws out that the Equality Act can pop up in this context, clearly under the more obvious, perhaps, sexual harassment side of things, and now we've got the reasonable steps, duty, etc., but also in what you described in an indirect discrimination sense, where it's well, we apply this policy to everybody equally, but through a protected characteristic, same-sex relationship you touched on, claimant may say, I was less able to comply with that policy, i.e. disclose, because of the concern about what might happen. And now you, employer, have to objectively justify your pursuit of the policy and what you did in response.
And that might be having the policy which says, and the application of the policy which says, we understand there may be circumstances where individuals feel that they don't want to disclose or their relationships, and having a very narrow circle of who that information is disclosed to. But I think there's still going to be the issue potentially that will arise that some individuals just won't want to, even if it's a very narrow circle of people within the organisation, they're not going to want to tell them.
Yeah, and I'm going to ask Rustam about that in a second. But isn't it interesting? That just shows you how tricky the situation can become, because in the pursuit of behaving in a way that's justifiable under that indirect discrimination context, other groups will come straight back to that consistency point. Other groups will say, well, I know that person didn't disclose it to you, and I can tell that nothing was done about it. Now, the answer might be that's because of a protected characteristic, and we needed to do X, Y, and Z. But the other party doesn't buy into that at all. They just say, look, I can just see that group of people gets away with it, and I don't. So it's not, the consistency point is not straightforward. No. It's that point about it's not always meaning the same response to the same response to everybody that has the situation. It's responding consistently to the particular facts. But Rustam, coming to the it's a very real uncomfortable issue, isn't it, that we often speak to employer clients about. For example, when the senior employee that's perceived to be indispensable has, for example, failed to declare a relationship. This will be a familiar story to each of you, I know. But the organisation, from some part or other of it, feels unable to take action or unwilling to take action that it would normally take because of that person's value, and feel that, the fear of losing, for example, the huge client that's tied to them. You've been around that loop, I'm sure, Ruston, but it'd be interesting to get your thoughts on it.
Well, it's very interesting, I have to say, listening to both you and Abby just over the last sort of couple of minutes about application of the policy and circumstances where an employee may say, well, I think I have a protected characteristic and the application of that policy has a particularly difficult or difficult impact on me. And I think that, again, that is so difficult because it's the concern there is the impact of a backlash or a reaction that colleagues or certain people might have as a result of finding out not about the relationship, but about their sexual orientation.
Yeah.
But I don't think the issue, that core issue of the relationship and the operation and applicability of the power dynamic changes just because it's a homosexual relationship or a lesbian relationship, or so it is very difficult. But I obviously see the argument that it but I think what it also for me throws up, and maybe this makes me sound like a real old man now, is that's an example and an issue which, to be honest, I've not come across during my time in practice. But what I have seen change considerably is the point, Adam, that you were asking about, which is where there's a senior person and somehow the sense is, oh, we can't touch them or we can't lose them. I'm absolutely not for a minute saying that there aren't organisations, including some very large ones, where that doesn't still happen. But I think the mood nowadays, and it's probably changed over the last sort of 20 or 30 years, the mood nowadays is that isn't a basis upon which we can make our decision. We're going to have to accept that if this behaviour is inappropriate, or if there's a risk of the perceptional power imbalance, that needs to be dealt with, and indeed without growing about any of my clients. Had one in the last sort of 12, 18 months where they had exactly this issue, and it was about another director and a co-founder of a pretty large business, but the remaining directors just said, we cannot be seen to permit this to happen and occur, and they accepted that both individuals, as it were, had to be dealt with. And with the senior one, he actually had to leave the business. So I actually think that has changed. I appreciate that's a sample of one, but I do think that mood in that sense, because of all the headlines and all the stuff that's gone on, say, over the last kind of 10 years, I think that needle has shifted quite substantially. And I think whereas we used to talk about who's going to be moved, and are we going to move the junior one, and not always, but often that would tend to be a female employee in a context of a heterosexual relationship, and that would be some form of sex discrimination. I do think the needle on that generally has moved, but very interesting, as I say, going back to what you and Abby were talking about, looking at those different contexts and saying, actually, is that now an area where that's problematic? But there, as I say, I think you have to disentangle the concern as to why there is a concern and what gives rise to the need for a policy in the context of regulating and managing relationships, and why the employer needs to know about it. And Abby flagged a really sensible, good point, obviously, about how the information is shared, how many people know about it, equally where there is that sensitivity, things that are, in inverted commas, secrets. I always sort of think it's always quite tricky to try and maintain and hold too many secrets or confidences, because they just end up being weaponized as well.
Yeah, I mean, there's so many interesting elements. That Abby, I'm guessing you agree with that there has been that trend and shift towards employers being less likely to be saying, we just need to find a way to not deal with this one. And I wonder if that's driven. Well, it will be driven in part by employers, obviously, over decades becoming generally more conscientious and considerate of these issues, but also this point about the reputational risk and needing to be seen to have dealt with things in the right way. I have the sense definitely is something that with social media age has shifted dramatically.
Yeah, I think it's shifting. I think I'm probably a little bit less positive than Rustum on it. I think there's a lot more work to be done for a lot of organisations. I still think the pressure of someone who is a big earner, sort of big hitter, is still there for a lot of organisations. And when push comes to shove, there are some boards that just feel that if they can pay off an individual and retain the cash flow, then that is an easier decision to make than actually dealing with the problem, which of course doesn't get rid of the overarching problem. And there's a lot more risk on organisations now with the new duty,
and your reliance so heavily in that scenario on confidentiality and people honouring that and not paying money for a settlement that actually the lid is blown on it later. And we all know how hard it is to actually police and enforce, to even prove and evidence where the information came out, let alone chase down someone who's agreed in the context of some kind of settlement to do it. And of course, we've had legislation seeking to deal with this around enforceability, haven't we, in the last few years? So, but I get what you're saying. Some organisations will still take a calculated risk and weigh up the commercial drivers on against other factors.
Yeah, and I think a lot of employers will probably think, well, we're not ITV, we're not Harrods, we're probably going to be tomorrow's chip paper. If there's a reputational issue, we think we can probably ride that out. Now, I think that is changing because of things like supplier questionnaires, more due diligence on supply chains, organisations wanting to work with quality organisations. So I think in time, I'm hopeful it will continue to change, but I think that there's work to be done.
So one of those questions is about at the more extreme end of this, what legal issues arise in respect of employers who might just say it's simpler for us, or we might believe we have good reason to just have a blanket ban on relationships, which might involve them having to sort of demand that couples end their relationships. And Rustam, I know you did an opinion piece on this not long ago, so it's an area of interest for you. What sort of issues might the employer end up facing if they take that right over at the other end of the spectrum approach?
Well, I think the first thing to say is that in this country, it's very, very rare indeed. It's more common in the States, where they would term them non-fraternisation policies, which would cover the sorts of things we've been talking about where there's a relationship perhaps between a line manager and a subordinate or colleagues, but where they will perhaps outlaw altogether relationships between colleagues. There's certainly an understandable degree of sort of pushback, and just sort of feels a little bit, in inverted commas, wrong for us in this country for employers to outlaw completely or prohibit personal relationships between individuals. But I guess in the context of this revision to the law, and I suppose I look at it as a revision to the law rather than a huge new piece of sort of legislation. It's caught the attention, of course, because it potentially, the headline of, well, up to another 25%. But I mean, I think if the working environment is such that harassment is essentially permitted, or a blind eye is turned to it, then whether we're talking about a 25% uplift, it's already unlawful, even sort of pre-October. There is, of course, that sense of it's just going too far. What business is it if the employers don't have a right to a private life under Article 8? And Article 8 does provide some qualifications to that right, but the qualifications are actually sort of relatively limited. So I think it's somewhat untested to see where we would end up, where an employer has such a policy, an employee is in breach of it, the employee is then dismissed by the employer, and the extent to which the employee is able to claim Article 8 as part of the reason perhaps why they didn't do it, and particularly if it's going to be allied with one of the points that we were talking about earlier on, where perhaps there's concern about disclosure of sexual orientation. So I think it is a tricky area, but one can absolutely see in terms of applying it, like most things, I suppose, in life, to take a slightly more extreme position sometimes is a little bit easier, and you avoid some of the shades of grey that you would have, where you say, well, there's a duty to disclose, but in certain circumstances and with certain qualifications.
Yeah, no, that's really interesting. I suppose in some ways we're saying if you take the win of having a blanket policy that's easy to apply, you have to accept that there's a risk that someone will be able to challenge it, and their circumstances will mean that they're able to to be successful in doing so, and that you're just going to accept that may happen, but we just treat everyone the same in perhaps a wrong rather than right way.
Well, it'll be in old money. It's back to whether it be a lawful and reasonable instruction to require the employee to notify. And again, one can see circumstances where, looking at it through one end of the telescope, the answer would be absolutely. But there'll of course be other cases where that might be a bit harder to make out.
Yeah, indeed. Staying with you on another quite complex area, if I may, Ruston, which is this point about relationships that have broken down or are breaking down. And we've already started to touch on some of these points, but we know that it's not at all uncommon for the grievance involving sexual harassment to have a backdrop of relationship at work that's broken down, or indeed the mismatch between one party to that relationship in terms of their perception of where the relationship is and is it continuing in the other. That kind of concern that one party says they were clear that it wasn't going to continue and the other persisted with it. That raises all sorts of issues, doesn't it? But I suppose it's one of those risk areas for employers to be mindful of in this context, and links into your point about the uplift and the harassment piece. Not sure where my question was in that, Ruston, but I suppose it's about, maybe you could just give us a bit of an insight to the sorts of issues you then, in terms of investigating and trying to get a clear factual position in one of those very nuanced scenarios where it was consensual and then one says it was no longer so.
Well, talking a few moments ago about the right to private life, I mean, you can see how trying to gather information, and particularly in the kind of current age, and obviously, WhatsApp messages, what right or entitlement does the employer have to seek to access those? What expectation can they have that they will be provided? How sure can one be that the whole trail is being provided rather than it being a sort of an edited version? So gathering evidence and information. There's the practical difficulty of what you can get and whether you'll get the whole picture. There's of course the whole sensitivity piece then about who else do you go to, and there may be others obviously on the periphery, as it were, of the relationship who may or may not be able to sort of comment on it. So I mean, this sort of drives back to having to then investigate the relationship if it's gone wrong, or if one party, as it were, is calling time on it. It is absolutely the employer just being the jam in the sandwich, caught as the jam in the sandwich.
Yeah, it will feel like that. Well, we know from working with clients on this issue, it will feel very much like that, and that it's impossible for them to confidently take a position that balances all the competing issues and interests, I suppose. A challenge, definitely. Taking things a step further, Abby, you might have a situation, mightn't you, where the relationship at work actually arises between your employee and an employee of a client or a supplier. Not that common in my experience. Probably the listeners will be thinking, thankfully so. But what sort of issues might come up from that in terms of the breakdown? Thinking of if that then breaks down, for example, if the client is said to have been the party that persisted, you might have a complaint from employees saying, actually, it's not another employee, it's this client employee that's been persisting. That can throw up, I guess, a different set of issues.
Yeah, I mean, I think you've got legal and commercial sort of issues at play there. The duty to take all reasonable steps to prevent sexual harassment in the workplace from October extends to third parties. So the same sort of issues are going to arise for employers in terms of undertaking risk assessments to establish the risk of sexual harassment within the workforce and from third parties. And of course, if you are having a policy, that should probably extend to expectations, relationships with clients, suppliers, third parties, and disclosure of that. I mean, the reality
Ruston,
is...
do you agree with that?
Go on.
Yes, I do.
Excellent.
Very exquisitely succinct. No, I do as well. I mean, why wouldn't you if it is a real risk?
And I think so that's the legal side. I mean, the difficulty for employers is there's very little that they can do to control the acts of a third party. Is the reality, and so that does present risk for an employer in this context. But that's where, your risk assessments, consultation with staff, which is recommended in the draft ECHR guidance, is going to be important in terms of legal risks and protections. But alongside that, there's the commercial reality that relationship breakdowns could cost the business money if the client chooses to take its business elsewhere, or potential conflicts of interest. For example, if there's pressure on pricing or disclosures on pricing to one client over another, there's those sorts of issues for an employer to work through if the relationship, even before it's broken down, if it does sort of have the employer's blessing, for want of a better word, those sorts of commercial considerations to work through.
Yeah, that throws up a thought without overthinking this, and trying to keep to time. Do we think that the requirements around disclosing the relationship should be approached any differently in the context of it being a third party? And linked to that, does that then maybe not compel, but does it mean that to be optimized in this, that actually that third party, in terms of our relationship with them, should be made aware that if a relationship arises, then it under our policies it will be disclosed to us, and so your staff should be aware of that as well? Or am I overthinking it?
No, I think it's a good point. Unusually, I'm feeling more optimistic than Abby today. Again, looking at things over not in the very short term, but over the medium term. We've seen all sorts of policies, whether it's now around anti-bribery. Obviously, most organisations of any size will have modern slavery and other policies. And the reason why they're relevant is that's in the context of commercial relationships between organisations, saying how we expect you to behave. You might be one of our suppliers. You might be, principally through the context of the supply chain. So one could see, and I don't want to overstate it, but one could see, if you like, that there's already more than a basic set of precedents, as it were, for organisations to say these are the expectations that broadly we have of our people, and these are the expectations which we will have of yours. Now, that's of course not to say that will end up being universally applied and every employer of every size will do it, but in that context of an expectation to say, if you come and deal with us, this is what we expect. I mean, really what we're saying is it's about transparency. The pricing piece, for instance, that was touched on, is there an unfair advantage that is being obtained by one or other organisation because of a personal relationship? And really, that's just a parallel to, I think, what we're talking about in the workplace. So I don't see it as personally materially different. I completely accept that there is a different set of commercial considerations, but it does still come back to what is the organisation at its core, and what are the values? And we know, as obviously employment lawyers talking a lot to HR professionals and others in that space, how much that has changed over even the last 10 or 15 years, and the level of expectation that there is amongst employees of organisations to see that their own organisation behaves well and in a generally kind of moral and sensible way, and that they want their organisation, as it were, to expect that of others. Now, I'm not being pie in the sky, but as I say, I'm not saying in the next 12 months, but I could just see that run over the next kind of 5 to 10 years, and the way that things have changed in some of the other areas we were talking about. So that's me being upbeat for a change on one of these
very
podcasts.
Good. Oh, we like that. Does feel like, as we come to a close, that if it hasn't happened recently, it'll be a good time for people to dust off existing policies in this area, and that's good food for thought. Really, very interesting, that point about, have we thought about this expansively enough? In terms, does it really capture all of the areas where we might have an issue? Because we'd much rather kind of anticipate them than be caught out. So, but we're coming up to time. So, my and finally question to you both is what I mean, this might be just summarising thoughts you've expressed earlier, but what additional complexity do you foresee the duty to take reasonable steps to prevent sexual harassment is going to bring to this area, if any? Let's start with you, Abby.
Okay. So I think the duty to take reasonable steps does have the potential to be very wide. It's intended to be preventative and proactive, but the difficulty I think, some employers are going to have is where to draw the line, particularly with regard to relationships at work. How far is far enough? The temptation is to put a complete ban on relationships, but that does have some difficulties that we've touched on, and I think that the likelihood is that would just there'll still be the same number of relationships, they'll just be driven underground and you're not going to have the visibility, but you'll probably have the rumours, and therefore you have enough knowledge to know that it is a potential problem, and therefore you're going to have to put all the same steps in that you would have had to do, but without the same amount of information. So I think that will be a challenge, and also I think there will probably be an uptick in claims from individuals where relationships have soured. So I think that's where it's important to be clear about expectations and parameters about the issue, so that you can try and prevent it from happening in the first place, but also seek to comply with your duties as an employer.
And I suppose not get too carried away with the duty as the basis on which to row really hard into a harder policy, because you still have to balance and think about the other Equality Act issues we touched on, and the Article 8 stuff that we touched. Employers could look and go, right, well, this gives us carte blanche to really just move much more aggressively to ban it, and because we've got this duty. Rustam, your thoughts to close?
Yeah, no, very much agree with what Abby was saying. I think it's combination, as ever, of training and, dare one say it, almost kind of enlightenment, but actually thinking about these issues, because I think the difficulty will be that knowledge, if I can put it like that, of a relationship will be had at various points by various people in the organisation, and they will react to that little bit of knowledge differently. Some people will take the view and say, well, it's nothing to do with the employer. Some people will ignore it. But when one goes then and investigates and looks at it, of course, that everybody will be an expert, as it were, with hindsight, and say, well, look, that manager knew over there, somebody knew over there, and there was insufficient action taken to ensure that, for instance, an individual wasn't being harassed or otherwise treated sort of unfairly. So I think that's going to be the complexity and the difficulty, because you're dealing with lots of different people who will have a slightly different take on what this issue will be, and everyone will feel they're right, and somehow the employer's got to sort of pull all of that together, and it has a lot of, I suppose, imputed knowledge is really what I'm saying.
Yeah, really good place to close, because of course sometimes you only find out who was right, in inverted commas, when you get all the way to the tribunal, and the tribunal panel has the job of trying to cut through it all and take a position on it, balancing these competing interests. It's very difficult to predict. So thank you both. A really interesting discussion. Hope listeners have been given plenty of food for thought there, and maybe we're all going to rush off and dust down the policies and start thinking about how we might want to update them. Do remember to follow us and follow the podcast on Spotify, Apple Music, iHeartRadio, or wherever you get your podcasts. And for more information about our podcast, jump onto our website or follow us on LinkedIn, and you will be able to obtain a written summary of this discussion on our website soon. Thank you all for listening.